Well, hello there. Thanks for joining me. I am Dr. Jen, and this is my life as a landlord. Today, we're exploring the location-specific tenancy guidelines for Wisconsin. All of the cheeseheads up there, thank you so much for joining me. In all of my location-specific episodes, I've included hyperlinks to that specific location. So in this case, it's Wisconsin. So if you look in today's show notes, there are just a ton of resources that I'm going to go through shortly here. And along the way, if we happen to add one or two, we'll have it. So, yeah, each of my location specific podcasts is set up in the exact same way, answering the same four questions. What is the basics of that area? What are the nuances of that area? Some guidance about abandoned items left behind by a tenant in that area, and then last is where do you go to get help in the local area of Wisconsin? As I answer these questions, you'll see me screen share all kinds of documents, like I said, that are hyperlinked in the show notes. And I really enjoy figuring out what is on the bingo card, and you'll see me go through this. That I've done so many of these location-specific episodes that I see the most standard items that every place seems to have, and sometimes they don't have. And so I'm going to keep track on the bingo card as we go. And then at the very end, we'll go through that bingo card together just to see, what's unique, what's different, what's missing, and we'll go from there. But I must tell you that as we go through this, even if I get every single thing in this episode 100% accurate at the time of recording, 5 minutes later, laws can and will change. So I need to make sure that you understand that regardless of what we're doing here, which is giving you a running start, you've got to do your own due diligence of your own location, your own municipalities, your regional district, your county, whatever it might be for Wisconsin. You've got to make sure that you are up to date, most current, and the most applicable for where your rentals are. I'll give a shout out to today for today's sponsor, Aloha Capital Investments LLC. If you want to know more about real estate investing, especially what Michael and I are up to, check that out, alohajb.com. Okay, I'm going to screen share right now. So if you're watching at My Life as a Landlord on YouTube, you're going to see the first of, looks like 6 hyperlinks that I've got here. And so for this one, this is the Wisconsin State Legislature. I really like it when we actually have the government uh, sponsored one. This is not like a for-profit, mass site. This is not a law firm. This is actually the government site explaining about landlord tenant in Wisconsin. Now, this is just a few of the information, and of course, it's all hyperlinked as you go through, and there's more to it. And this is the legal part. Remember, this is tenancy law, so this is the actual law, right? And so there's a couple other resources that might be way more user-friendly than looking at a law. But let's look through of what they've got here. This is Chapter 704, Landlord and Tenant definitions, and some of this is down below. It's hyperlinked. They talk about lease, periodic tenant, premises, rental agreement, tenancy at will, requirement of writing for rental agreements and termination. So this is good. You must have, let's see. Oh, and they put in here too that you can serve someone by means of email. That's kind of interesting, which is good. A lot of places are updating that, but that's actually in here. You can actually email for service. Okay. Assignment proof. Disposition. Oh, here we go. Disposition of personality left by tenant. If the tenant removes from or is evicted from premises and leaves personal property, the landlord may presume, in the absence of a written agreement between the landlord and the tenant to the contrary, that the tenant has abandoned the personal property and may, subject to a certain area, dispose of abandoned personal property in any manner that the landlord in its sole discretion deems appropriate. If the landlord disposes of the property by private or public sale, the landlord may send the proceeds of the sale minus costs of the sale and any storage charges first stored to the Department of Administration for deposit into appropriate. The exception is medical items. Okay, so medical items, if they leave behind medical items, looks like medication or prescription medical equipment, the landlord shall hold the property from 7 days on which the date of the landlord discovers the property. After that time, the landlord may dispose of the property. Interesting. Okay. 7 days. Otherwise, it is deemed abandoned. Wow, like right at the time. Okay. Right. Abandoned immediately, except for medical stuff is 7 days. Okay. And then, so then they are talking about if there is a manufactured home or mobile home, a titled vehicle. Notice that the landlord will not store property. If the landlord does not intend to store the property, personal property left behind by tenant, except by provided by some section, the landlord shall provide written notice, and when the tenant enters into or renews a rental agreement, the landlord will not store any. So you must put that into your lease that you're not going to store any. If you are a landlord in Wisconsin, you want to make sure you've got that. And they put in here too that this does not apply for self-storage facilities. Interesting. Okay. Disposition of personal property left by a trespasser. Oh, this is different. Listen to this. Water heater thermostat settings. A landlord of a premises which are subject to residential tenancy in Wisconsin served by a water heater serving only that premises shall set the thermostat of the water heater at no higher than 125 degrees Fahrenheit. Before any new tenant occupies that premises, or a minimum setting of what the water heater, you don't want to have a scalding. Oh, that's interesting. Limit for water heater. Scalding protection. Okay. Okay. Repairs, duty of the landlord, duty of the tenant. This is pretty standard stuff. And I am going to go to the next one here as we go through, but check-in sheet. So a check-in sheet is not it's not a condition inspection together. It's basically, it says the landlord shall provide a new residential tenant when the tenant commences his or her occupancy of the premises a check-in sheet that the tenant may use to make comments about the condition of the premises. The tenant shall be given 7 days from the date that the tenant commences his or her occupancy to complete the check-in sheet and return it to the landlord. The landlord is not required to provide a check-in sheet to the tenant upon renewal of the rental agreement. And this does not apply when you've got a pad for a mobile home park. That's interesting. So it's a check-in sheet for tenant only. It's not a walkthrough with the landlord. I've never seen that. Okay, let's look at it. Says credit and background checks. Landlord may require prospective tenant to pay the landlord's actual cost up to $25 to obtain a consumer credit report. Actual cost up to $25. Okay. And let's see. Or the tenant can provide a credit report that is not more than 30 days old. So even if someone's got either credit monitoring or they want to they're applying for multiple places, which happens. So they might have one credit report that they've already paid for and they can provide that to the landlord. But that does not necessarily so there looks like, okay, so wait a minute. So it's up to $25 for a credit report, and there's up to $25 for a background check as well. And of course, for all of this, you have to, if you get it as the landlord, then you have to provide a copy to the tenant if they don't already have access to it. So it's up to $50, but it's really, it's actual costs. Okay, transferability, assignment remedy, electronic delivery. Okay, any rental agreement may include the provision that permits the landlord to provide and indicate agreement by electronic means of any of the following: copy of the rental agreement and any document related to the rental agreement. Yes. Security deposit, any documents related to the accounting and disposition of the security deposit and refund. And then a promise made before initial rental agreement to clean, repair, otherwise, advance notice of entry. Advance notice of entry, all can be sent by email. Okay. Lien of the landlord, acts of a tenant not acts of a tenant not to, okay. Notice, this is about domestic abuse. Requirement that the landlord notify tenant of automatic renewal clause. You've got to give notice that it's automatically renewing. Termination of tenancy for imminent threat of serious physical harm, and that includes changing the locks. And it's for safety, right? Termination of tenancy by landlord. Changing locks. Termination of tenancy at death of a tenant. If you've been listening to this show for a while, you know that I talk a lot about tenants passing away. I also talk about landlords passing away, but we talk about death of a tenant. What do you do to tenants dying inside the unit? What happens if they get hospitalized and don't come back? These are real life situations that are going to happen more and more as we have an aging population with their health that's starting to fail. So this one says, this is 704.165, termination of tenancy at death of tenant, except as provided above. If a residential tenant dies, his or her tenancy is terminated on the earlier of the following 60 days after the landlord receives notice, is advised, or otherwise becomes aware of the tenant's death or expiration of the term of the rental agreement, which makes sense. So if there's no escalation clause in the event, like let's say they're in a 1-year lease and they die, sometime during that 1-year lease, obviously the tenancy is going to end. There's no acceleration. Like if they die in 6 months in, they're not responsible for the next 6 months. Like, yeah. Yeah, so this is interesting. They put this in. A landlord under this section may not communicate or contact with a family member of the deceased tenant's family for the purpose of obtaining from the family member rent for which the family member has no liability. True, true. Okay, notice determine failure to pay rent or other breach by tenant, month to month, week to week. And let's see if they've got anything. Looks like they are 5 days after giving notice, tenant fails to pay. So yeah, so it's pay in 5 or get out in 14 is what it looks like it is. Yeah, pay in 5, get it out in 14. So okay, lease for more than 1 year. Criminal activity. Don't do that. Okay, manner of giving notice. Notice by landlord. Looks like leaving a copy. Oh, this is how you serve each other. Okay, okay. Removal of tenant, effective of holding over after an expiration of lease. So there is an abrupt, because they're using that word holdover. So it is an abrupt end unless there is a renewal discussion. Or it does not automatically convert, but it can convert if that's how you set it up. Damages for failure to vacate. Okay, withstanding. Okay, withholding from and returning security deposits. When a landlord returns a security deposit to a tenant after the tenant vacates the premises, the landlord shall withhold from the full amount of the security deposit only reasonable amounts necessary to pay for any of the following. Looks like normal wear and tear, unpaid rent for which the tenant is legally responsible. So it looks like, yes, you can use the security deposit for unpaid rent. Payment that tenant owes under the rental agreement for utilities. Payment that the tenant owes for direct utility service by a government-owned entity to the extent the landlord then becomes liable for the tenant's non-payment. Like if they set up water and they didn't pay water and then it goes back to the landlord, that would be something they could use the security deposit for. Further, unpaid monthly municipal permit fees assessed against the tenant. And again, the landlord becomes liable. Any other payment for a reason provided non-standard rental provision. Okay. Normal wear and tear. Timing for return of security deposit. Landlord shall deliver or mail to tenant full amount of security deposit, less any amounts, within 21 days. There it is. 21 days. Return of deposit timing. And let's see what the penalty is if they don't. It's usually like some multiple, like double or triple. Let's see what it is. Um, I don't see it. Application to residential tenancies. Okay, okay. Okay, well, recovery of rent, damages by landlord, scope of section, burden of proof. Okay, I'm gonna keep going, only because we've got, oh, here's another one. I'm just gonna keep going a little bit, but then I'm gonna move on to the next thing, but I keep seeing more that's on the bingo card, so I don't want to go too fast. Retaliatory conduct in residential tenancies is prohibited. So this is on the bingo card for sure. Except as provided in the section above, a landlord in a residential tenancy may not increase the rent, decrease services, or bring action for possession, basically try to evict them, or refuse to renew a lease or threaten any of the foregoing if there is a preponderance of the evidence that the action or inaction would not occur for the landlord's retaliation for the tenant doing any of the following. They basically complained, did it like a code enforcement complaint, complaining to the landlord about a violation of some kind, exercising legal right relating to residential tenancies, basically involving tenant unions or making some kind of a complaint. So they can't, landlord cannot decrease the amenities, increase the rent, try to do an eviction. And typically there's like a time frame for that, but I don't see a time frame here. But it is, landlord retaliation is definitely defined. Yes, but no time frame. Okay. Sex offender registry. Oh, this is interesting. Disclosure duty. Okay. A landlord or his or her agent has no duty to disclose to any person in connection with the rental information related to the fact that a person is required to register as a sex offender. Wow. Okay. Hmm. Okay, and then they have a bunch of stuff for self-storage facilities. That's not dwelling. That doesn't make sense. Um, in this section. So I'm just going to keep going to the next one because they have things in here that might look like it's on the bingo card, but it actually isn't. Okay, so like I saw late fee. Well, that doesn't apply. Okay, so that's that first one. And I know there's way more, there's hyperlinks all over the place. So we're gonna go to the next one. So this one's the landlord tenant guide. Now, typically what happens in these location specific episodes, we get into the law and it's very legalese, which is where we just were. But then there's usually like a guide, like a user-friendly guide, and that's what this is. So this one is Wisconsin Administrative Code Chapter 134, ATCP 134. And this, of course, is hyperlinked in the show notes, as I've mentioned. So the rules that do not cover, basically, they have to be in a dwelling, right? Rental agreements. You can read this yourself. I'm not going to just rattle this all off, but if I see something on the bingo card that we haven't gotten yet, I will do that. Disclosure agreement, utility charges, code violations, earnest money deposits. We have not gotten what the limit is here. Earnest money deposit is the money a prospective tenant gives the landlord to return in the option of entering into the rental agreement for the future, so the landlord can settle a person's application. The purpose of these deposits is to protect the landlord from the possible costs or losses if the tenant decides to not rent from the landlord. The rules do not prohibit earnest money deposits, nor do they set the maximum on the deposit. Earnest money deposits is the money a prospective tenant gives in the option. Okay, so this is, oh, this is like an application fee. Okay, so it's not a fee. If they give them earnest money, a landlord may not accept earnest money deposits until the landlord identifies the specific dwelling unit for which the prospective tenant is being considered. But that's different than the credit check or a background check fee. That's not a deposit because remember it's all paid with money, but it's different. Returning earnest money. Okay, so they do. Okay, that's a little bit different. I'm talking about security deposits. Here it is, security deposits. Uh, Security deposit check-in procedures, pre-existing damages. When a landlord requires a security deposit, the rules establish the check-in procedure, which we've already talked about. First, by accepting any security deposit, the landlords must provide written notice that the tenant has 7 days to inspect and document any pre-existing damages. I'm just shocked that they don't have a walkthrough that the tenant can go through and say the whole place is trashed, even though it very likely isn't. But second, the landlord must tell the tenant they have a right to receive a list or description of any physical damages which the landlord withheld money. If the tenant requests a list of previous damages, the landlord must provide the list within 30 days after receiving the request. And returning the security deposit is 21 days. Limitations, non-payment of rent. Still hasn't said how much it is. I mean, I can always say it's typically 1 month rent that becomes a deposit, but that's not always the case. And it hasn't actually specified it yet. Tenant failure to leave a forwarding address. Okay, so when they depart, the rules require the landlord to mail the security deposit and/or accounting for the security deposit to the last known address, which could be the rental unit. This rule even applies even if the last known address is the dwelling unit that the tenant rented under the rental agreement. Tenant should notify the postal service and the landlord's agent of their change of address. Okay, promise to repair. Okay, so I guess that's it. There's prohibited rental agreement provisions. You can't put in anything that basically counteracts the law. Okay, oh, unauthorized entry. So this is all about abusive access. Landlord tenant law provides that the landlord may enter a rented dwelling only in certain specified circumstances unless the landlord and tenant have agreed otherwise. Although the landlord has no unfettered right to enter the dwelling unit without the tenant's permission, state law does authorize landlord to enter the premises without advance approval under limited circumstances, which is usually there's got to be advance notice unless it's an emergency, right? So advance notice, and advance notice is only 12 hours in advance. Okay, 12 hours advance notice. Okay, inspect the premises, make repairs. And you must do it at reasonable hours. They don't say what the hours are, but they just say reasonable. Um, and advance notice is not required if a tenant requests or consents in advance that the landlord can go in, or a health and safety emergency exists, or if the tenant is absent and the landlord reasonably believes entry is necessary to preserve or protect the premises. Okay, confiscating personal property. The rules prohibit landlords from taking tenants' personal property, preventing a tenant from taking possession of their personal property. Yeah. Retaliatory eviction. We've talked about this already about retaliation and failure to deliver possession. Okay, late rent fees and penalties. A landlord may not charge a tenant a late rent fee or late rent penalty unless rental agreement specifically provides for such a penalty. So it must be in the lease. And if the tenant was late paying rent the previous month and gives the landlord the rent payment for the current month, the landlord must first apply the payment to any rent currently due before applying any part of that late payment. Landlords may not charge tenants a fee or penalty for not paying late. Okay. So it doesn't say what it could be. So it must be in the lease, but no details on what it could be. Okay. Non-standard rental provisions, criminal activity, terminating a tenancy. So 5 days to remedy or pay. This goes with mischief as well. So you have 5 days to either pay or correct an activity. When noticing like let's say you get a warning letter, it's 5 days to cure, 14 days to get out, basically. Yeah. Change of ownership, foreclosure. And then additional information, there's a ton of hyperlinks down here. And then you've got the Wisconsin Department of Agriculture, Trade and Consumer Protection for Wisconsin. And they've got an email, website, phone number, and so and a QR code, that's something different. So you can, if you've got any questions, concerns, you want to know what this is all about, then you can go there. And all of these 704, we were just in 704, residential rental practices. Let's click on that and see what happens. So food lodging. Okay, nothing. Okay, let's go to the next one. So this one is Department of Agriculture, Trade and Consumer Protection. This is where the tenant and landlord items are in Wisconsin. And what you should know before you rent. So this one I think was tenants' rights and responsibilities. It has a downloadable fact sheet, which I think I have as the next hyperlink. So we'll go through that. But we'll just go through this just to see if we've got anything. This is basically helping a tenant figuring out how to do their check-in sheet 7 days after the start. So this is basically how you do it. Flush the toilets, check for lights, making sure all the lights work, look for smoke detectors, water heater, what you should know while renting, terminating the tenancy. If you break the lease by moving out early, you may be obligated to pay for the remainder of the term unless another suitable tenant is found. Yep, there could be an escalation clause. Talks about non-payment of rent, healthy and unsafe conditions, and then it actually has the Wisconsin State Bar Lawyer Referral and Information Services number and website, which I think I've got hyperlinked in here as well. And then, of course, it's got all the contact information at the bottom of the page as well. So that's good. Okay, so this one is frequently asked questions, Bureau of Consumer Protection, tenants' rights and responsibilities. And this is it's a 2-pager, so it looks like it's like a marketing slick kind of a thing. For tenants. And I just want to scan this because again, we have not seen, like, what am I missing? Grace period for late rent without penalty, none stated. 5 and 14. Lease wording, security deposit method, bond payment, separate account. There's nothing about that. We haven't seen anything about rent increases. We don't even know how much the security deposit can be. And yeah, there's not a lot in here. There's a lot of items. You can certainly ask for help, but it doesn't actually give a, yeah. Okay, we've gone through all this before. Okay, so this one was about unclaimed property abandonment, and which I think we've already gotten what we need for the sake of checking that box. And this one's unclaimed property, abandonment, safe deposit boxes. So this isn't just, this is like all unclaimed property, not just in rentals. But I'm just going to scroll down just to see if there's anything else. Records, recovery of property in different states. Considering that items that are left behind are instantly deemed abandoned and that the landlord can sell it unless it's a medical item, I guess that doesn't surprise me. Okay, let's go to the last one. So this one was Landlord Tenant Law Update, what Wisconsin attorneys need you to know. And this is from April of 2025. There is a YouTube video. I'm not going to play the video. I'm just going to look down on this. And it's talking about eviction attorneys negotiating fair housing, manufactured housing, fee shifting claims, Wisconsin Landlord Tenant Manual. Okay, let's click on that. Maybe that's a good idea. Oh, they want you to buy it. Wow. $349 if you're a non-member. Holy moly. My goodness. That looks like it is for lawyers though, but wow. Okay, well, it might be something that you invest in if that's what you want. Chock full of sample forms, including numerous Wisconsin legal blank forms authored by someone. Hmm. Okay, well, so I included that article, but it doesn't look like, in fact, we're just gonna Google some of this stuff. I'm just gonna throw this in here and see. Is there a Wisconsin standard lease agreement? And see what comes up. So of course you've got all these Law Depot, legal templates, blah, blah, blah. But it doesn't look like it has a actual template. Um, yeah, so it's saying to go to one of these other ones for templates. So it does have wording. It does have the lease wording. Okay, so let's go through the bingo card because I think we've got what we're going to get here. I don't think we're going to go too much further. Okay, in Wisconsin, tenant application fee, actual cost can be up for, in fact, let me share my whole screen so you can see what I'm looking at. Okay, stop share. Let's go back to the whole screen. Okay, tenant application fee. So I've got the Wisconsin stuff on this side. I've got my bingo card here. Tenant application fee can in Wisconsin, actual cost can be up to $25 for credit check, up to $25 for a background check. So basically up to $50. Grace period for late rent without penalty. It didn't say a grace period per se, but if you're moving towards eviction and you've given notice to your tenant, it looks like they have 5 days to either pay or to remedy a behavior. It's the same thing, 5 days to correct or 14 days to get out. It's that all of the above. Late fee, it says it's got to be in the lease, but it doesn't have any details. Like typically I'll see a percentage or flat fee or a max dollar amount or something. There will be guidance about a late fee, but I didn't see that. But let's just check. Let's see. Wisconsin late rent fee. Let's just see what it says. Okay, so reasonable fees. Landlords can charge late fees for overdue rent, but there are no specific statutory limits on the amount. They must be reasonable and specified in the rental agreement. Okay, so that's why we didn't find any because of it. And Wisconsin law does not require to provide a grace period for late rents. Okay, well, that's the answer. That's why we didn't find it. Like we did take a look. Security deposit method, a bond payment, does it have to be in a separate account? Let's see, because I didn't see anything about security deposit amount. Let's just put that. 1 month's rent. But it says it's not strictly limited by state law. Well, again, we didn't find it. So landlords can charge up to 1 month's rent for unfurnished properties and up to 2 months rent for furnished property. Unfurnished 1 month and for furnished 2 month for security deposit. Interesting. Okay, and then returning is 21 days. We've already seen that. Okay, lease wording and details. It does have information about what is supposed to be in the lease, but it doesn't actually have a lease template for you. Is an emergency contact required in the event of tenant abandonment, incapacitation, death, or imprisonment? There's no emergency contact required. However, best practices, you want to have someone. In fact, if you don't, like right now, I'm just thinking I don't have that either for a lot of my tenants. I should probably get that in the new year. Um, yeah. Pets and animals. Is there a pet deposit or pet rent? I saw zero, nothing about pets in Wisconsin. Let's put something in here. Pet, uh, pets in tenancy law. Let's see what it says. Pet policy. So governed by the lease agreement. So there's nothing in there. There's nothing in pet tenancy law about deposits or pet rent at all. We didn't see anything about it. Delivery of signed lease required, yes, and you can email it. Condition inspection at move-in, not like what you'd see. It's a check-in sheet for the tenant only that they must do within the first 7 days, and they do it by themselves, which is really interesting. Standard warning letters or wording, no, not as a part of the law. Are there required maintenance inspections? No, not that I saw. Rent increase, didn't see anything about rent increase, and I bet that it's up in the air. Rent increase laws. In 2025, increase laws remain unchanged with no statewide rent control laws in place. Landlords can raise rent by any amount, provided that they give proper notice. And typically it's one per year, but it doesn't even say that. It just is completely open. No rent control. Okay. Renter's insurance, not mentioned. Abuse of access is defined, but it doesn't have exact hours. It just says reasonable. Landlord retaliation definitely is defined, but there's no timing. They just said you can't do it, and then there's no timing. So it's just indefinitely for that length of tenancy. End of a fixed lease is abrupt. It does not automatically renew. Condition inspection at move out. It does not talk about a condition inspection at move out. But I'm assuming that if you have the check-in sheet that the tenant does in the first 7 days and they give that back to the landlord, that when the tenant departs, then the landlord does a walkthrough and compares. But again, it's like the tenant versus the landlord. It doesn't actually align. Sorry. Okay. So it just seems like they're setting everybody up for a bit of a battle here, especially if there's deductions. Return of deposit timing, 21 days. Can you use the last month's deposit for rent? Yes. And then how long can you give a notice? It was notice in 5 days, out in 14. And then abandoned items, it's deemed immediate. Like there's usually like a value amount of storage. There's timing that you're trying to get a hold of the tenant and say, hey, I've got your stuff, or the time you've got to store it, inventory it. None of that in Wisconsin at all. It's just at the time of the abandonment. That's it. So okay, that wraps up our look at Wisconsin. Each of my location-specific podcasts is set up in the same way, answering the same 4 questions. What are the basics of that area? What are the nuances of that area? Guidance about abandoned items left behind by a tenant in that area, and where to get help in your local real estate or province. As I did that, you saw me keep track on my bingo card of standard items I see most often in tenancy laws in different locations. What helps is a summary for this location. And this is the same format for every single one of my location-specific episodes. So if you're interested in another geographic area, you already know how it's going to be laid out. It's just a different location. One more time, I have to put a big asterisk. This episode is not all-inclusive. You must research further in your specific area for whatever may change and whatever may apply for you. If you're listening to this podcast, chances are you're either new to real estate or you're already a landlord in the state of Wisconsin. Things you can do to help yourself are be familiar with Wisconsin tenant law, and 2, get in the room with other landlords. Now, you can either physically get in the room or you can virtually get in the room. Physically, you can get in the room by doing other meetups and in your local area, and that could be with real estate, apartment owners associations. There can be whatever it is in your local area, but get where the landlords are talking. Same thing on social media. There are plenty of LinkedIn groups and also Facebook groups that talk about landlords. If you get on there and say, hey, I'm a Wisconsin landlord, and you say, I've got this question or this problem, usually the other landlords will chime in, or even other landlords in your area will likely be in that group and they can help you. But I hope that you enjoyed today's show all about Wisconsin. Don't forget to subscribe to My Life as a Landlord for more expert advice and real stories from across the globe. I'm recording this today from Maui, Hawaii, and I think it's important to say that for location because real estate takes you places. Where do you want real estate to take you? Join me in the next episode live right now in the library, episode 218, that's 218, about the great state of Wyoming. We'll see you there.